When no will exists, grief gets mixed with admin and it hurts. Today, write a single page note, put it with your important papers so decisions are faster in a crisis. If there's no will, your estate will follow intestacy rules, not your preferences. That can change the beneficiary and delay probate for the people you love. The shock is rarely about money first, it's about who is allowed to do anything at all. Someone is grieving, and at the same time, they're being asked to prove authority in writing to banks, insurers, and sometimes even to family. And what people expect is simple. What the law does can be surprisingly strict. In general, intestacy just means someone dies without a valid will. When that happens, the law sets a fixed order for who inherits, and a fixed order for who can apply to deal with the estate. That person is not an executor because an executor is appointed by will. Instead, someone has to apply for the legal right to administer the estate, and that can slow everything down. Some assets may pass outside the estate and some do not. It depends on how things are owned and what paperwork exists already. If you died this weekend, who could actually act and who would you need to prove it to? Start with the people side, because this is where intestacy hurts feelings and creates delays. If you marry, separate, or have a child, the trigger to review your will and your choices of executor and guardians. A common problem is presuming a long-term partner automatically has the standing to deal with everything, especially if you're not married or in a civil partnership. Another is forgetting that stepchildren are not usually treated the same as children under intestacy unless they're legally adopted. So your idea of the kids may not match the legal list. If you have young children, guardianships is the point people avoid, then regret avoiding it because it is about day-to-day care, not just inheritance. You know this is improved when the right adult can explain plainly who would act first and why without an argument starting. Based on your last family chat, write down who you'd want as guardian. If you weren't here tomorrow, then ask your partner if they'd agree. Now the assets and documents, because intestacy is not only about who gets what, it's about what can be accessed quickly. Buying a home together is a trigger to confirm how you own it, because the wording on the title can change whether a share passes automatically to the other owner or falls into the estate for probate. One situation I see often is a couple with a joint home and separate savings, and the savings get stuck while everyone waits for authority. Pensions and nominations can sit in a different lane again, and the decision maker may look at your nomination but is not always bound by it, depending on the scheme rules. The common problem here is having a mental list of accounts and policies, but no clear current record of what exists and what name it's in. You know this is improved when someone you trust could gather the key documents and explain ownership in one sitting without hunting through old emails. Because so much confusion comes from missing paperwork, the fix is really simple. Just keep one up-to-date list of your main assets and check it matches what's on file. If you want the law to sound like you usually need to write it down. For the detail on intestacy and in England and Wales, read official guidance on gov.uk and speak to a qualified solicitor or will writer about your circumstances. Tonight, write a single page note of the people you want involved and the main assets you have. Put it with your important papers. That's a habit that costs little but saves your family stress when they need it most.